What do you mean by that?
Yes, it is a military constitution. Okay. You see, under the 69 constitution, Nkrumah had been overthrown. So the constitution they did was a very fair one. That's the 69 constitution. Then 79, SMC took, led by General Akufo, and then AFRC, Armed Forces Revolutionary Council, led by Flight Lieutenant Wallace. They were not interested in playing civilian politics. As a result, the constitution was seen to be the National Defense Council, led by Flight Lieutenant Rawlins, was interested in metamorphosing as a democratic political party. So they just removed the P, and then NDC remained. As a result, being human, they decided to make the constitution such that the president would have the same military powers as if there was no democracy. Okay. And that is the reason why the constitution was crafted in a manner that if the president would want to dismiss a chief justice, just let's get anybody in Ghana, and then we'll bring in an application. And therefore it will counter and then outnumber that of the two. As a result, anytime the president would want to dismiss you, he would easily get you.
With the aid of the Council of State.
With the aid of the Council of State.
Very political.
So just a small screen, you understand. My worry is with the NDC, MPP as a party. Right. You see, MPP, the first MPP president, was a very senior and experienced lawyer, J. Kufuor. He knew these problems associated with the constitution, and he felt it was okay because the constitution gives power to the president to turn a man into a woman and a woman into a man. It's not a real democratic constitution, but what? A transitional constitution. It's been discovered that all military governments that transit into civilian, the constitution they build are always military. And then when the two-term mandate had ended, then opposition that comes to power becomes the first real to do the right thing. Unfortunately, Kufuor did not do it for Ghana. It was rather another NDC man, the very NDC or PNDC that crafted the constitution to aid the president to do whatever he liked in power. That felt that the constitution was not good for the people of Ghana. President Atamel started. He died midway. Talk about another MPP, what do you call it? A blind eye to the whole thing. And even his last, nobody should touch the constitution. And then President Mahama, working meticulously with the tenets of Article 146. Now your party comes back to say that it was the wrong thing that was done. What wrong thing was done? It becomes so easy, the easiest belief that with all the experience I've gained in life as a lawyer and as an adult, I believe that what should be done to Article 146 is that, one, the Chief Justice office is not an ordinary office. When we have an ordinary case between the two water, you would empanel 5 judges of the Supreme Court, all because of this bottle of water. What about the senior judges of the Supreme Court? Not to be appointed by anybody, but according to their own level, majority, it must be unanimous. That it should be 7 judges. You are appointed the Chief Justice of, that should be the position. Because when we appoint a president, until the 4-year term is over, nobody is able to dismiss him. What impeachment? Superior Court judges read, backed by 2 judges appointed by the president. No, I'm saying that it should be 7 senior justices of the Supreme Court.
And what would you classify as misbehavior for a Chief Justice? Must it relate directly to the dispensation of justice or some administrative matters?
The two go together. Right. One, you say that there must be a stated misbehavior. It's not defined anywhere in the world. But when you talk about misbehavior, it is anything that is outside behavior. Okay. So what is your behavior as a judge or as a Chief Justice? You know that it goes with morality too. You think that as a Chief Justice of Ghana or as a senior justice of this country, and then there is a funeral at, let's say, Latebi Okoshi, and you are found there, you take off all your clothes, and you are found with children, no. I mean, and then people will point that this is the Chief Justice of Ghana. It's completely immoral, even though it is not illegal. Then you talk about the Chief Justice having taken so much alcohol competence, but it is wrong. So the two go together. That is why we have stated misbehavior. And then the next one to do with administrative incompetence, they go hand in hand.
Whenever there is a change in government, we will see people filing petitions for the removal of the sitting Chief Justice.
The answer is yes and no. The answer is yes and no. The yes is the fact that once we have begun it, it becomes a precedent. And other people know is that there's this Nigerian proverb that says, when the frog in front falls into a pit, the others following him will take caution. You see, in the case of Mrs. Justice Tokonu, there were serious flaws relating to her performance that brought about all this. So even if the president wanted to, you may attempt to put a particular Chief Justice in the same scenario. What about if it becomes so flawless to the effect that if the five people
we are humans, and so
if you have nothing against it,
so certainly you have some flaws here and there.
That flaw should not be brought to the work as a Chief Justice. Okay. So ensure that you in Ghana, if during the lifespan of the Fourth Republic from 92 to date, nobody has ever experienced that. Today, because of Tokonu, advise you to ensure that
past 11, the vetting process should begin any moment from now. Let's go over to the telephone and speak to lawyer Ishaq Ibrahim. He's a member of the MPP communications team. Good morning to you, Counsel.
Yeah, good morning to you. I'm actually a member of the MPP Legal Director as well, and a lecturer at the UPSA Law School.
Right, very, very well noted. So any moment from now, as I said, the vetting process should begin. Your party, the minority in Parliament, has raised issues. They feel that the case pending before the Supreme Court should be allowed to come to a logical conclusion before this vetting process begins. What are your thoughts? It does appear that will not happen.
Yes, I think common sense also suggests that would be the most appropriate thing to do. That if somebody had made an application to the court to vindicate her rights, and she believes she was wrongly removed, it's already acting in that particular position. What is the point in rushing it? What is the main objective they are trying to achieve? After all, he's still acting. But there is a former Chief Justice who is in the court to have their say. There's no point in rushing it. After all, she wants to vindicate her rights. If, for example, at the court fair, and now you have already nominated and vetted a new Chief Justice sworn into office, aren't we further muddying the water? So if they were to say she was wrongly removed and Ghana had to abide by that ruling, are you then going to? There's no need to rush. But then I heard the Speaker of Parliament saying it's a constitutional duty on the part of the Parliament, and that there's nothing that bars it. But just listen. You yourself just listen to what I have just said. Doesn't it make sense? If you say there's nothing that bars you, go ahead to perform a constitutional duty that has been placed on you, and yet somebody is trying to vindicate their rights in court. And if the court found in their favor, what have you done? Are you not further muddying the water? So I think the minority position is right. It's in line with common sense. Not just in line with the law, but it's also in line.
The Speaker is saying that we have a constitutional mandate. We will go through the process.
Doubtful whether what the Speaker of Parliament said is right. You see, and this is the Speaker of Parliament who is noted for getting things wrong. He famously declared 3 or 4 vacancies in Parliament. When we say he did so wrongfully because he was claiming powers under Article 110. When we made it clear that this was a general power the specific power was given to the High Court under Article 99. So the Speaker is known for getting things wrong. I won't be surprised if it turns out that the court itself will confirm that what the Speaker is saying is just clearly wrong. So for me, there is no point in rushing to perform what he calls a constitutional obligations on them. For me, the wise thing would be let the court make a decision, and then from there, if the court rejects the Chief Justice, the former Chief Justice application, you go ahead and make the appointment. If the Chief Justice, if the former Chief Justice, if the court decides that the former Chief Justice was wrongly removed, then you can reinstate it or whatever remains, rather than muddying the water by bringing a new Chief Justice. And if the outcome of her case is to be favorable to her, then you are just going to remove somebody else. It doesn't make sense to me.
Ishak, this case before the Supreme Court can travel on end. There's no definitive time frame attached to this case at the Supreme Court. So you are saying that as a country we should wait until any such a time when the Supreme Court rules on the matter before we can go ahead to vet the acting Chief Justice?
I don't agree with you that you're saying that the end is not near. It can travel indefinitely. I don't agree with you. The Supreme Court and the court system can definitely prioritize this particular one. Sometimes the court works in what we call the triage system. I'm not sure whether you're familiar with A&E, triage, as in triage. So some cases require emergency hearing. Others, of course, can queue in a normal way.
But this case is actually before the High Court and the Court of Appeal as well.
Yes, they could equally give it a priority. It's not just limited to the Supreme Court. Any court knowing very well that the office of the Chief Justice is very important can prioritize it. Maybe we should be doing that.
So what happens after the vetting process has been concluded and the acting Chief Justice properly sworn in?
Yes, so this is what I said, that will further muddy the waters. If it turned out that the Chief Justice was wrongly removed in the MPP, that the whole idea of removing the Chief Justice was cooked up, even when they were in opposition. They are just using these legal principles and Article 146 as a clock to just validate that particular wicked plan they had in opposition. Other than that, I don't see the need to be rushing this particular issue. Other than somebody have already made up their mind, they have already decided, and everything is just window dressing.
Constitution.
And as we have consistently argued, it wasn't. It was just used as removal of the Chief Justice. It's just so unreasonable. Many of these offenses they are accusing her, the members of the executive would have committed worse offenses than that. And as one of your panel members was explaining, what is stated means vacation. So for me, Article 146 was activated. They just use this as a clock, as an excuse to achieve whatever wicked plan they intended to achieve.
The former Chief Justice said that a removal is a threat to judicial independence moving forward. You agree with her?
And if you make the bench into submission. So I agree with her, and I've consistently argued on that particular line, that yes, making it easy to remove the Chief Justice or any other judge, especially when the executive is taking part in it, yes, can undermine judicial independence, because obviously they will know that their jobs is no longer done.
Let me pick your thoughts. So, if in the future your party decides to also use Article 146, you are a lawyer. As an individual, what will be your thoughts? What will be your response? What will you be saying if it has traveled?
I think this is just a hypothetical question. Nevertheless, I'm prepared to answer it. NPP as a party is founded on the rule of law and will never use Article 146 as an excuse for any other thing. So I don't even countenance it. Article 146 will never be used as an excuse for a party that believes in that particular thing. And if it comes to the Chief Justice, I believe the NPP as a party would take that office so seriously that the removal of the Chief Justice should be the last resort. And what he should be alleged to have done will be so clear and obvious to members of the public that nobody can even argue in favor of her. They can see most of the reasons that they gave out. I mean, these are flimsy excuses. For example, the allegations that she has incurred certain expenses, something that a state institution, the Auditor General, have had a look at it and didn't find it to be an issue. And yet, an individual found it to be an issue. And then a panel found her
saying that
making the Chief Justice removal so easy, when in fact the Constitution talks about separation of powers. So if there is separation of powers and you make the removal of one branch, and then we need to look into it. And as we always, national years have gone, so I'm only hoping that this Constitutional Review Committee will have a clear look at it. I favor the American system whereby Parliament should play a major role in removing the Chief Justice. And hopefully maybe 2/3 majority of parliamentarians should be the right way to go.
All right, thank you very much. Ishaq Ibrahim is a private legal practitioner, a member of the MPP Legal and Communications team there. So, Mr. Frimpong, it does appear that in most cases, depending on which side of the law you are, you argue differently. I mean, you have
but he supported whatever I said. Yeah, implicitly he supported the fact that I mentioned the Constitution was a military, and then 2, the fact that it makes the dismissal of a Chief Justice in Ghana by the easiest in the world. And then indirectly, he also supported the fact that NDC, and for that matter, Rawlings, since 92, has not continuously been in power. They ended their journey in the year 2000. January 2001, MPP came to power and remained in power until January 2009. What did they do about it? Then they came to power again under Akufo-Addo. They didn't do anything about it. So as he spoke, I believe that he felt he was guilty, not as an individual. A whole period of 8 years to do something about the Constitution, you did not do it. And now somebody comes to power and asks him that there is a high court, you go to Court of Appeal. If you are not satisfied with the judgment, from Court of Appeal, you go to the Supreme Court. In Ghana, it can take you between 3 years and 10 years to get to the Supreme Court. So all that Tokonu seeks to do is this man, Baffoe-Bonnie, could remain an acting Chief Justice. It's neither here nor there, since we do not have any time period for the High Court to complete its work. He mentioned the ECOWAS Court. The application by Tokonu to the ECOWAS Court was done in July, and we are now in November. The case has not been called, and I don't think the case will be called. So you are saying that when our Constitution is a sovereign Constitution...
That case was called. The Attorney General told them that they should allow the country exhaust internal processes. Okay. And that motion was filed.
So it was ever the internal process has long been exhausted. It has not been called again. So you are telling me that we should have waited for ECOWAS for the next 10 years to give us the serious blunder. And they should, you see, when you are at fault, you should admit it, because we are only human, that they should fault their first 2 presidents for not doing anything about the Constitution. And then they should praise the last 2 presidents of the NDC for attempting to do something about the Constitution. You know, this about the Constitution. So I believe that they should rather give credit to the 2 presidents of the NDC for the attempt they have made. And they should also thank President Mahama for actually invoking whatever power that Article 146 has got, so that every Chief Justice will begin to set up, so that the next MPP president, if we would ever have, and we come, we are not going tomorrow or the following day. We'll be there for more than a century. So if they will ever come.
You've been at it for a very long time.
Yeah, the CPP has been very inactive and very soon. You see, we were looking at things and we are still looking. And from 2028, we see the massive change. And all that I'm trying to say.
Ishak assures us that his party would never, want to consider Article 146, in the future.
Well, based on precedent, I believe they wouldn't want to do that. And that's the reason why they never attempted to do something about the Constitution. But there is the need to do something about the Constitution, not only in terms of the appointment and dismissal of a Chief Justice. Look at the position of the EC, Electoral Commission. Why should a president who is contesting an election together with his political party be allowed to appoint the Electoral Commissioner? It is completely, as the Ishak EC is equivalent to that of the Court of Appeal judge. Anybody who has that mandate, who qualifies to be a to be an Electoral Commissioner of Ghana, bring your application and then make the judges of the High Court, Court of Appeal, Supreme Court, backed by Ghana Bar Association, to vote to elect one as the Electoral Commissioner. The moment you do that, among them, one, to become the EC of Ghana, whichever way you see it, you come to the conclusion that the appointment to have a hand in the dismissal of and then the independence of the judiciary. Right. In much the same way, the president and nobody within the executive should be given power or even a hand in the appointment of the EC. So I think there are so many bad things associated with our Constitution. That is the reason why when somebody is made a chief executive of any public institution in Ghana, he is compelled to toe the line of the ruling, but all because of the way when the government falls and the new government comes, everybody at the top also falls with the previous government. Right. I believe it is wrong.
There are some who have compared the office of the Electoral Commissioner to the office of the Chief Justice. Some also have disagreed that both are not
really independent.
The same in terms
of... They
are
not the same, but they are not independent, right, because of the way in which they are appointed and the man which should completely be made apolitical. That is to say, politics must not have any influence in their way. Look at the Auditor General. You appoint somebody as the Auditor General, and he's going to audit all the public services, including Office of the President and all the ministers. And you are saying that if I'm President Anochi, I should appoint an Auditor General who will do a fair work in connection with his master who appointed him. So there's something fundamentally wrong with the Constitution. And I am saying that, looking back to 1992, how people suffered, struggled to bring NPP to power, that very year, 1993, they should have done something about the fight against the president who is working in line with Article 146, and then an innocent person such as Justice Baffoe-Bonnie, you want him to fall together with Tokonu. I believe it is completely unfair.
All right, so we already getting pictures from Parliament, the vetting committee preparing to start the whole vetting process. We see pictures on your screen. We have security chiefs, members of the legal fraternity. We see the MPs seated. At this point, I'm not able to say if we have members of the minority side, but we see a full house from the pictures we see from Parliament. And any moment from now, the vetting should begin. The advertised time was 11 a.m., some few minutes past 11. And so it makes sense of the whole process. Early on, we spoke to Ishak Ibrahim. He is a member of the MPP legal team and the communications team as well, bringing his thought to the conversation. At this point, we'll go for a short break. We are back to continue the conversation. You want to stay with us when the whole vetting process begins.
is set for the vetting. May I call? Honourable members, our revered guests, upon this Parliament of the Republic of Ghana, grant that it may perform its high duty as in their sight, give divine guidance with discernment and vision. Well, O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving. Bless the effort of to the vetting of my Lord, the Chief Justice to be. Honourable members, following the nomination of the Chief Justice, His Excellency, the President of the Republic of Ghana, by a letter statement, honourable members, to the House, is to vet Baffoe-Bonnie as the Chief Justice and approved by this House as Justice of the Supreme Court of Ghana. He is now being Justice. We are therefore here to have you. You are all welcome. Honourable members, as the tradition demands, we shall proceed to call on the clerk to have the Chief Justice sworn in.
I hereby proceed to lead the nominee to take the oath.
Chairman, for the record.
These proceedings must be orderly. When you have an issue, the practice is that you catch the eye of the speaker, and in this case, the eye of the chairman. You don't have a right to ask anybody to stop proceedings for you to say whatever you want to say. Honorable, you are welcome. Honorable Habib.
Initially, you said the clerk shall swear in the Chief Justice. And this is Parliament, and for the record of Parliament, that will be captured. So if you are correcting it, then direct that. Your earlier statement should be expunged from the record.
Unfortunately, you don't have a right to tell me what I should do. Once the correction has been made, may we proceed to administer the oath. Clerk of the committee.
I hereby proceed.
I, Paul Baffoe-Bonnie,
Swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue
touching the matter in issue
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you.
Thank you very much. Honourable members, procedurally, I will ask the members of the committee to introduce themselves. It's going to be self-introduction, starting from my left. Honourable members, only members of the committee.
Nana Ejei Baffoe leads committee.
Yes.
Thank you, Mr. Chair. My name is Hassan Tampuli. I'm the Member of Parliament for the good and virtuous people of Gushegu in the Northern Region, and then Deputy Ranking for Constitutional and Legal Affairs Committee of Parliament. Thank you, Mr. Speaker.
Thank you, Mr. Chairman. I'm Honorable Anthony Mie, Member of Parliament for Odotobri in the Ashanti region. I also serve as the Vice Chairman for the Committee on Judiciary. Thank you.
Thank you, Mr. Chairman. My name is Kwame Enyimedwentry, Member of Parliament for Santiachem Central, and the rank
MP Nkoko, Chairman of the Judicial Committee. Thank you.
Kwame Apiakodua, Member of Parliament for Mfantiakwa North in the Eastern Region. Subject member. Petitions. Petitions and judiciary, sir. I'm here as a subject matter member. Thank you.
Petitions Committee.
Petitions, and I'm a member of the Petitions and Judiciary.
217. Strictly subject matter committee.
I'm here on the ticket of the
and
judiciary,
then leadership of the subject matter committee. So you are either a chairman, vice chairman, ranking, or deputy ranking of the committee. Honourable members, let me use the opportunity to clarify Standing Order 217. We do not want any confusion. If you know you are not a ranking member, deputy ranking, chairman, and vice chairman of the subject matter committee, please perpetually.
Thank you very much. Patrick Boamo, Kankwe Central, member of
Bawi. Leadership.
Of Parliament for Tolong, First Deputy Minority Whip, member of the committee.
Ano Dompre, Salma Dreji, Minority Whip.
Yes, now on my right.
Chair, my name is Beat Anwatasmo Zieden. I am the MP for Laura and ranking for Judiciary, subject matter representative.
Umar, MP for Zabzugu in the Northern Region, a member of the Appointment Committee.
Thank you, Chairman. My name is Shaibu Mahama, MP for Daboya Mankargo, Chairman for Constitutional and Legal Affairs Committee of Parliament, and a member of the committee.
Thank you, Chairman. MP for Ada Leadership. Thank you.
Ladi Ayayamba is my name, MP for Pusiga, ranking for Chieftaincy and Culture, and a member of the Appointments Committee.
Chairman, thank you. CJ Nominee, you're welcome. My name is Roxanne Nelson Dapamapo, MP for the good people of Southline, member.
Leadership.
Thank you. My name is Kweku Ricketts Hagen, Member of Parliament for Cape Coast South and the Vice Chairman of the committee. That's the Appointment Committee. Thank you.
Afenyo Makin, MP for Ifutu and ranking for the committee.
Bernard Ahiafo, Chairman of the Appointment Committee. People also call me the Kingmaker. So, honourable members, commencement. Yes, I see you pulling the microphone. Do you have an issue?
Chairman, with respect, thank you for the opportunity, and I shall proceed with my opening remarks, which remarks I make for and on behalf of the minority caucus of this committee.
Honorable Minority Leader and the ranking member of the committee, I shall accord you every respect and the time to raise your issue. My only hope and prayer is that whatever issue that we are going to raise must be raised within the rules that governs this committee as well as the entire parliament. The floor is now yours.
Chairman, thank you very much. With a quote from Shakespeare's Macbeth, Act 1, Scene 7. First, as I'm his kinsman and his subject, strong both against the deed, and as his host, who should against his murderer shut the door and not bear the knife myself. Besides, this Duncan has borne his faculties so meek, has been so clear in his great office, and his virtues will plead like angels, trumpet-tongued against the deep damnation of his taking off, and pity like a naked newborn baby, striding the blasts of heaven's cherubim, housed upon the sightless couriers of the air, shall blow the horrid deed in every eye. Tears shall drown the wind. I have no spare to prick the size of my intent, but only vaulting ambition. Chairman, we hear with a heavy heart, but an unshakable resolve to defend the Constitution of Ghana, protect judicial independence, and uphold the rule of law. We gather to vet a disputed nominee for office of Chief Justice of Ghana. This should be a moment of national pride and institutional renewal.
I have an issue.
Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control.
Honorable Minority Leader. Honorable Minority Leader, just hold it a second. Yes, Honorable Ayarga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we got. I want you to focus on those two orders. 1, 2, 3, 2. But my objection is founded on content. Ranking member of the committee refer to, I believe, the nominee as a disputed nominee to the post of Chief Justice. Shall not raise any question. 1, 2, 3, 5. A member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. I recall that just a couple of days ago, I think Thursday, the same member brought a motion to the House trying to stop this committee from sitting to vet the nominee. The matter was exhaustively debated, and you, Mr. Speaker, gave a ruling. Subsequently, the Speaker himself, because you sat as a Deputy Speaker, the Speaker himself came and recounted the motion and also gave a ruling. So this issue about the propriety or otherwise of whatever happened has been raised on the floor, debated extensively, and a ruling given. Apart from that, Order 1237, 1237 says that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Judicature of this country in Parliament except
by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody, and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object. So I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
Yes, Honorable Habib, there is an issue raised.
Yes, that's what I'm...
And I must give the floor first to the person who raised the issue in relation to which objection is being taken to respond. Yes, Honorable Minority Leader and the ranking member of the committee. This is the issue raised to part of the submission that we have started raising. What is your response to it?
Chairman, first of all, acting in bad faith, seeking to obstruct the rather peaceful processes we have started, and as it were, try to use his numbers to intimidate. Let me ask, the rule he relied on has to do with debate on the floor of the House. There are dark clouds indeed in this country where freedom of speech by mere operation of a supermajority, you cannot even as a member of parliament make your comment. I am not moving a motion. I am not debating. Please, Chairman, the rule he relied upon. You see, this situation where people move from here and there to create confusion and create their own jurisprudence must come to an end, with respect. Interruption of debate. That is, if you go to page 70 or the 122, the title there, the subtitle, interruption of debate. Debate may be interrupted by a point of order. Mr. Chairman, if the majority leader has anything to say in opposition to my opening remarks, he has a right bona fide as a leader of government business and as a leader of the House to also state his submission. I have seen him with his written submission, be it for his opening remarks or see that to you as a chair of the committee to read it for answered. But this process where, as it were, try to use it to deny you, don't say this. So every line that I read, he will censor it and say, you use this word. Mr. Chairman, we are not going to make... He says that the conduct of the Speaker, the Chief Justice, members and Justice of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. With the greatest respect. Have I raised any issue that is situated within the context of 123.7 to warrant this so-called objection? Chairman.
Minority Leader in silence.
Chairman, we are here to discharge a civic duty and responsibility. We are political actors who have our political views. The matters giving rise to the nomination is purely political, and every Ghanaian adult knows this. Your side raised it as a political issue during the campaign. You are going to remove Justice Tokonu as Chief Justice, and that has happened. If in my statement I contextualize to say that disputed nominee, it is our view we hold as a minority caucus. Right? Express it. We have to express it. And that is why I added by saying that this should be a moment of national pride and institutional renewal. Instead, it will fall under the executive and political that have to be obstructed by the majority leader when you have every unfettered right to raise your issues. Chairman, humbly, please control proceedings. Please take charge. Let our respected leader of government business understand that after speaking, after making my comment known on behalf of opening remarks, by the way, by way of conclusion, this is not the first time a leader in the minority is having this opportunity to make opening remarks. It predates me. From J.H. Mensah's era, he and J.H. Owusu Achampong, all the way to Alban Bagbin, MP for now Dole Kalio, and minority leader as he then was. The videos are there. Hansard is there. The Honorable Bagbin had unfettered opportunity to make his political statement on behalf of the minority, and they were not stopped on point of order. It got to Chair Mensah Bonsu, it got to Harun Edrusu, and recently, my own respected colleague, Dr. Kasiel Atufosen. The records are there. Let's not create a certain impression as if all it is you are majority, so we cannot even say a word. We must have our rights. These are our rights. We will state them, and you would also have the opportunity to state them for the record. Please, let us have some more.
Honorable members, as we call for the chair making a ruling, but honorable members are indicated as a preliminary issue that let us all operate within the rules. Yes.
If you read rule 1233, 1233, where in the opinion of the speaker, the words of a member used in a speech, and it doesn't matter whether the speech is at plenary or at committee, a speech is a speech in Parliament. So where, in the opinion of the speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugns the integrity of a member or any other person, the speaker may order that committee meeting room and you started. You refer to the nominee as Chief Justice. When you refer to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also disputed nominee. Disputed nominee. Disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination. If there is a dispute about some other action. So you have no right to look him in the face here before this committee and refer to him as a disputed nominee and expect me to sit here and not respond. So, Mr. Chairman, pursuant to our own rules, he has to withdraw and apologize to him for referring to him as a disputed nominee when he is not a disputed nominee.
Chairman, let me.
Honourable members.
Chairman, he has had two opportunities to make a point. Let me respond to
Honorable members, Honorable Minority Leader, listen to what I will have to say.
Okay.
Please proceed and raise your issue. Avoid the use of disputed Chief Justice. Once I do not have a right to refer to him as a Chief Justice, but Chief Justice nominee.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
I object again. I object again.
On the 22nd
I object again.
April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
Hold on. Honorable members, I think at this particular point, I must place on record that I have admonished that we should all operate within the ambit of the law. Honorable Minority Leader, be guided by Order 103D, and then let's make progress. And Order 103D, it states that a motion shall relate to a definite issue and not revive the consideration have arisen. Honourable members, by necessary implication, whether a motion or not, the principles of res judicata will not permit us that a matter that has been raised on the floor resolve to its finality would be permitted to be raised at a committee meeting. So, Honorable Minority Leader, refrain from anything that is relating to sub judice rules and let's make progress, with all due respect. Because Speaker has dealt with this matter, I have also personally dealt partly with this particular matter, with all due respect.
Chairman, the facts speak for themselves. On Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship, Gabriel Scott Puama, to trial the Chief Justice amounted to a travesty of justice.
Chairman.
The removal
our rules are clearly offended.
In the language
our rules are
of
clearly
judicial
offended.
accountability.
Because the rules I just read clearly offend that.
But
the rules clearly are offended. Chairman, the rules say that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Let me, Chairman, let me respond to him.
responding to the issue.
It doesn't fit in the rules.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman,
Honourable members, order. Honourable Oman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to.
Yes, before I address, I've made an observation. The learned Attorney General knows how much I respect him. He knows how much I respect him. And this Mayariga, leader of government business, was raising his objection. I remain quiet. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the contention that my reference to the committee's work amounts to attacking the conduct of its chair. With the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view leadership, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend Order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal. I'm not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't attack him. The caucus is talking about, please, Honorable Ayerga, let me finish. You were allowed to make your point.
Yes, but Honorable Minority Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed. Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? Where you have the right to say your own, you are the leader of the house. You have unfettered right to rebut. That is the debate we even have on the floor. When there's a debate, you take note. Where you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. we
Honorable
as members of the
Minority
public
Leader, kindly
criticize
conclude for me.
the work of even
Please
the
conclude for
judiciary.
me. Conclude for me.
I beg you, leader.
Conclude.
We all agreed, Chairman.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority members. We should be guided by the principles that Parliament, which has got to do with another, who may not have the opportunity to respond to it. Such a thing should not be made on the floor. Now, though Justice Gabriel Poma is here in person, at no point will he have the opportunity of responding to any issue raised about him. None of the committee members will have the opportunity to a conclusion to say that their report amount to a travesty of justice. Anything in relating to the committee and Justice Poma should be expunged from our record. That is my ruling.
Chairman,
Kindly proceed.
Chairman, let me protest the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That said, I will proceed. Truth Araba Isaba Tokonu was cloaked jurisprudence of
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable minority, interruptions. I will be compelled to listen to the person and make ruling.
This one is friendly. Opaque. It's friendly. Opaque.
Yes, Majority Leader.
Mr. Chairman, please. Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did he say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honorable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I would order that same be expunged from the record as if it doesn't exist. Honorable Minority Leader, proceed.
Chairman, with respect.
Chairman, with respect, he raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised the objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honorable Minority Leader, kindly proceed.
Leading to the removal of Her Ladyship Justice Araba adhered to any constitutional procedure.
Chairman,
And
Chairman,
we continue.
I hope, Chairman,
to say.
I hope, Chairman, that persistently,
Chairman, with respect to you.
Honorable Minority
Chairman,
Leader, if you can hear me out,
yes,
maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please let's refrain from all those things and be guided by our rules. So is it fair that a committee that in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this, who will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is. So I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect.
Honorable Tampuli, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is re-litigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And I look about what he's saying, we can't make progress.
But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampuli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order
Yes.
5.1, subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2, in any case not provided for in these orders, Mr. Speaker shall decide on a procedural question. And finally, 3, in exercising the power conferred under this order, Mr. Speaker shall act. It amounts to being guided by Order 5.
Rules, yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution, under
So you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say the Parliament. So, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to land. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable
comments.
Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule against. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to, when I read Order 24B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24 D have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip, it is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the rights of the minority. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman. And keep to the rules because I will object to anything that violates the rules.
But when we do this, it's not okay.
Mr. Chairman,
Minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions. Our own Supreme Court, the High Court, and the ECOWAS Court of Justice now challenge the constitutional validity of that removal. Not one has been heard on its merits. Not one has been determined.
Mr. Chairman,
Yet, while these cases remain pending,
Mr. Chairman,
while the very
Mr. Chairman,
question of whether a vacancy exists
I object,
remains
Mr. Chairman,
sub
I
judice.
object.
There is a nomination
I object.
to replace.
I object.
Can have the floor.
Araba Isaba Toko.
Honorable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this House, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings, and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are Afenyo Markin. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afenyo Markin, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away whilst I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
If it gives you the opportunity, because he is on the floor. Tell him, when he said I should hear.
You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable and Honorable, what do you have to say on the issue?
We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look into a banter between the majority leader? And I'm surprised at some of the issues being raised by the majority leader, saying that, show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show me the rules that tells us that every Friday you should be standing behind the dispatch box and presenting petition. There are no rules on that. But it's part of our practice. And majority leader, with respect to you, you know this. So don't keep referencing that, saying that, show us the rules, show us the rules. It's not just about the rules. It is also about our practice. Now, the very rule the rules were made with specific functionality. And the 103 you quoted is on admissibility of motion. No, it's motion. And he's giving us conditions for admissibility of motion. So when you read the heading, so you are interpreting the rule to suit your understanding. A while ago, Tampuri just referenced Order 5 and says that interpretation will be done by the speaker. All of us are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong here, saying that is normal. Why don't you take your note when he's done, then you can present your version of the truth.
His law teacher started marking his sentences long ago. I'm not the first person to mark his sentences. His law lecturers marked his sentences for years.
Anytime it appears to me, I'll conclude. Because you are pushing me to conclude, I'll conclude. But interestingly, the majority leader catches your eye every time. It is surprising that he always catches your eye. When we also draw your attention, let us also catch your eye. We also have something to say. Parliament is not just about the majority leader. For heaven's sake, I'm representing the good people of Insama Dredji. And when I have the minority leader, we will also obstruct that you are going to obstruct him. We will also this vetting. When you put down his points.
Honorable,
can I finish taking copious notes? He should write down his points. And regardless of the fact that he's a majority, he's a member of parliament like anybody else.
In terms of Order 1, the minority filed a motion that this Honorable House, having regard to Articles 110, Clause 1, 125 to 127, 144, Clause 1, and 146 of the 1992 Constitution and Standing Orders 57, Rules 1 to 3, Order 93.
Is that the motion Speaker rule on?
Yes. For the records, I'm reading the terms of the motion they filed. Yes. Order 103, Rule Standing Orders, resolves to source committee and a plenary on the nomination of Justice Paul Baffoe-Bonnie as Chief Justice until all pending suits and applications in ECOWAS Court, suit number ECW/CCJ/APP/Supreme Court proceedings and High Court applications are finally determined or withdrawn. And that, in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination and the of the Constitution to appear before this House or before such committee as the House may designate to provide a comprehensive briefing on the status of all pending litigation relating to the removal of her ladyship, Justice Gertrude Araba Isaba Saki Tokonu, including but not limited to A, the identity, interim orders, or conservatory orders sought or granted. C, the relief sought in each proceeding and their potential implications for the office of Chief Justice. D, Ghana's international obligations under regional treaties relevant to the ECOWAS Court proceedings. E, the government's assessment of potential legal and constitutional implications of proceeding with the appointment of a successor Chief Justice while such litigation remains pending. And F, any other matters relevant to Parliament's informed exercise of its constitutional functions under Article 1141. Applicants of the motion.
Well, hold on. Let me hear you, Honorable Habib. What are you objecting to?
Chairman, Parliament and parliamentary proceedings and practices. A member is not to address the House. What Honorable Roxon is doing is addressing us. Whatever he's reading, Mr. Chairman.
Honorable, when a supplementary question is being asked. It is only when a supplementary question. Honorable Minority Leader.
I'm not done.
Conclude.
So, Mr. Group filed that the motion cannot be admitted. Now, the minority leader, as ranking member of this committee, is using a backdoor approach. He has rehashed the terms of this motion contained in a speech, and he seeks to read that speech before this committee.
Honourable member,
it
conclude.
cannot be done.
You've made your point. Yes, minority leader, let me hear you.
To the issue raised by the respected majority leader, which issue he answered, I would repeat the provisions in the said order. A motion shall relate to a depth of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. That deals with conditions of admissibility of motion should be read and construed within and then ask a question. The minority brought employees. He came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection. In spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even cases pending at the ECOWAS Court, at the Supreme Court, at the High Court, amount to us. The nominee, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it, to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it's rather because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Honorable minority
leader.
Let
me finish.
With all due respect.
You allowed the minority leader. I'm responding to his
asking
objection.
the minority leader to raise an issue. Order to play the fair game here.
If you make your point, we respond.
Honorable minority leader.
What is wrong?
Please. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said that. You've said that. You've said that. You've said that. You said that. You said that the nominee swiftly empaneled a court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter. Then we.
It is my view. It is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority to affect the outcome of a pending suit. That is what he says. He says that my reference to, because with respect, we have pending suits for over 6 months.
Chairman, the rules are clear.
No, it's not.
The rules are clear. The rules are clear, Chairman. The rules. So when you
just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone.
You will not have a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the Majority Leader is invoking supports the contention of the minority that are pending, that he has a problem with my earlier statement. If we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it. Okay, not for him to come in. I am coming in personally. Severally, I admonish you that a matter constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any entertained before this particular committee, because for me, that matter, procedurally and legally, is mute. It cannot be raised.
Have been raised, and each of them must have a response.
You see, when your leader is speaking and you're asking me to give you the floor.
The Majority Leader has raised this issue, and then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the Majority Chief Whip. The Majority Chief Whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch the attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the Majority Chief Whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the Majority Leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice, when eventually the court determined that all her reliefs are upheld, and then what becomes of us?
Yes.
What
Honorable
we are
Majority
doing,
Leader. Honorable Majority Leader.
you are hearing him?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished
him or me
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by, so that one, strictly any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, through this process, it is clear to us, however, that consistently there is a grand design to onion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, all of you are of the same stock. We, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them someday. That is all that they are doing. Chairman, that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say any. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, what the majority leader is doing, is not fair. He raises his issues. You don't have to respond. When you have spoken. When you are talking, you don't calculate the hours.
Honorable members, so it's time for cocoa break.
you.